My dear students, part 1 I have presented half of the provisions under the fair trial procedures, and now I'm going to present part 2 of this procedure, starting the where the slide 13 have provided parties to be represented by a competent lawyers, self-incrimination, expeditious trial, rights of the accused at the time of the trial, and some of these provisions are discussed in continuation of the part one of the video with respect to fair trial procedures. What are the parties to be represented by competent lawyers? To secure a fair trial, it requires not only the competent and independent judges and magistrates, but also requires able lawyers representing the parties. So lawyers must also be equally competent. Then only fair trial can be achieved. Crime is wrong against the society, therefore, the state is representing the society through public prosecutor and assistant public prosecutor in all cognizable cases. So, the prosecution will present the state case, the defendant concentrate entirely on the accused and present the case. Article 22, 1 of the Constitution and Section 303 of the Code provides that any person accused of any offense before any criminal court can defend his case by a lawyer of his own choice. Both Article 22, 1, 330 says a person can engage a lawyer of his own choice. There is no restriction in it. So this right begins from the time of arrest of the accused person, not at the time of the trial. From the moment he was arrested, he can take the help from advisors or help, whatever it may be from there. He can engage a lawyer. The right is recognized because so why this right is recognized that accused can engage a lawyer of his own choice, because this right is recognized accused has no knowledge of law, and also he had no professional skills to defend his case. On the other hand, the prosecution is conducting the other side was a competent and experienced prosecutor, experienced person. So, for our keeping in know all these things, a right has been given to the accused, and the accused person can engage a lawyer of his own choice. So, this is a fair trial. So, sometimes it is not possible for the person to engage a lawyer because of he doesn't possess sufficient means, because he was an indigent person. Further, the court also made a provision that we can a lawyer can be provided to an indigent accused person in trial before the sessions court. Later, the court enables the state government to extend this right to any class of trials before other courts in the state. In Sukadas versus Union of Territory, Arunachal Pradesh, the Supreme Court held that the trial court is under an obligation to inform the accused that if he is unable to engage a lawyer on his account of the property, he is entitled to obtain a free legal service at the cost of the state. So a duty is imposed on the trial court. He is under an obligation. He has to inform to the accused person the moment he appears before the for the trial. The court has to inquire whether he had a lawyer or not. Suppose if he is unable to had a lawyer because of indigent or poverty, the court should inform that the accused can engage a lawyer from a legal service authority at the cost of the state. Venue of the trial. The provisions regarding the venue or the place of inquiry or the trial are contained in sections 177 to 189 of the CRPC. But the general rule is that every offence is to be tried by a court within whose local jurisdiction the offence was committed. The place where the offence was committed, the court in whose jurisdiction it was committed, that court will have a power to try that offence. This is the general rule. Every offence is to be tried by a court within whose local jurisdiction the offence was committed. If the place of the trial is highly inconvenient to the accused, because it causes various other problems, impediments to defend his defense, or to preparation of his defense, that if the trial is conducted in such a place, it cannot be considered as a fair trial. So the place is very inconvenient, and it is not possible for him to prepare his case, that is to defend his case, because it causes many impediments, but still the court conducts a trial in that particular place. That is not a fair trial. What are the rights of the accused person at the trial? Fair trial is applicable only to the accused person or to the prosecution? To both. To both. Fair trial implies that it should be fair both to the prosecution as well as the accused person. But here we are confined only to the accused person, because since we are speaking about the rights of the accused, so we are speaking or confined to the provisions relating to the accused person. What are the rights that are available to the accused person at the time of the trial? Right to know the accusation, right of the accused to be tried in his presence, evidence to be taken in the presence of the accused, right to cross-examine the prosecution witnesses, right to produce evidence in defense, right to have a reasoned decision. First, right to know of the accusation. All the international instruments, even the provisions are also, we have seen that adequate time and facility has to be given to the accused person to defend his case. How he will defend case? First, he must know what are the accusation that is made against him. If he knows the accusation made against him, then he prepare his defense case. Suppose if the information has not been given to him, what the accusation is made against him, then what is the use of giving this opportunity of adequate time and facilities giving to the accused person? What is the use of it? So the first, the court provides section 228 to 240 to 46 to 41, that when the accused is brought before the court for trial, the particulars of the offense with which the accused is charged must be stated to him. First, the court must say, the presiding officer must say the accusation that is made against him. What are the offenses that have made accused him? What are the accusation made against him? That must be stated to him. In case of serious offenses, generally the court will frame the charges in writing. After framing the charges in writing, then it should be read and explained to the accused person. Second, trial procedure has to be conducted in the presence of the accused person. So the accused person must be present at the time of the trial on every occasion. The court should not proceed ex parte against the accused person. So by making the accused present at the time of the trial, he know what is the prosecution case, what the witnesses says against him, so that he can make his defense. He can prepare the arguments for rebuttal of such evidence. We are saying that the accused must be present at the time of the trial. His presence is necessary, but there is no express provision in the court to say that presence of the accused is essential. Nowhere the court says that the presence of the accused is mandatory or the presence of the accused is necessary. Nowhere so the CRPC mentioned it. There is no express provision in the code, but it can be inferred from section 317 of the CRPC. 317 allows the court to dispense with the personal attendance of the accused person under certain circumstances. When the court has given the discretionary power to dispense the personal attendance of the accused person in certain circumstances, means in the absence of those circumstances, the presence of the accused is mandatory, must. So, what are the circumstances that is listed out under section 317 of the CRPC, which exempt the attendance of the accused person? Personal attendance is not necessary in the interest of the justice. The accused continuously disturb the proceedings of the court, represented by a lawyer. These are the circumstances in which the court can dispense the personal attendance of the accused person. In the absence of these circumstances, the accused must be present at the time of the trial. HR Industries versus State of Kerala, 1973 case, where the Kerala High Court has stated the circumstances in which the personal attendance of the accused can be dispensed. Generally, when the offense is grievous in nature involving moral turpitude, personal attendance is the rule. The accused must be present. His presence is the rule. But cases which are in technical nature, which do not involve cases which do not involve moral turpitude, or where the cases the sentence is fine only, exemption should be the rule. If the offence is grievous in nature or the serious involving moral turpitude, the accused must be present. If the cases are technical in nature or involve no, do not involve moral turpitude or sentence fine only, then his exemption is the rule. But there are certain persons where the accused person is a woman, laborers, wage earners, or a busy man. Their attendance can also be exempted. Courts should see that undue harassment is not caused to the accused appearing before the court. This is very, very important. The third right of the accused is evidence must be taken in the presence of the accused. It is imperative that in all trial cases, evidence should be taken in the presence of the accused person. If the personal attendance of the accused is dispensed, then the evidence is to be taken in the presence of his pleader. And when the witnesses have been examined, evidence has been recorded, then that evidence must be read and explained to the accused person so that the accused can prepare his defense case and he can present in the argument a rebuttal of such evidence. If any evidence is given in the language is not understood by the accused person, then it is the duty of the court. The court must interpret in the language in which the accused can understand very easily. In that language, the court has to explain the witness's evidence. So 279 cast a mandatory duty on the court. The court has to interpret in the open court and explain it to the accused person. If the accused person is a deaf, dumb foreigner, not knowing the language of the court, and interpreter is not available, then the court to proceed with inquiry at the trial and which result into conviction. Then he will submit the whole proceedings with the record to the high court, and then the high court pass orders as it thinks fit. Right to cross-examination prosecution. This is a right of the accused person. He can cross-examine the prosecution witnesses. Denying the denying this right, that is cross-examination of prosecutioners, is not a fair trial. Similarly, right to produce evidence in the defense. Generally, the burden lies on the prosecution. The responsibility also on the prosecution has to produce evidence. Defense has no responsibility. But in such some cases where the accused want to produce a defense in order to prove his innocence, the court must permit him to produce the evidence. Denial or not permitting him to produce such evidence, he cannot be considered as a fair trial. Doctrine of atrophy acqui and atrophy convey. The concept of double jeopardy is based on the doctrine of atrophy acqui and atrophy convey. This class embodies the common law rule nemo debit vis vexare, which means no man should be put twice in peril for the same offense. The meaning is no man should be put twice in peril for the same offense. This concept has been substantially incorporated in Article 20, Clause 2 of the Constitution and also embedded in Section 300 of CRPC. You can find both in the Constitution and also the CRPC. According to Article 22 of the Constitution, no one can be prosecuted and punished for the same offense more than once. No one can be prosecuted and punished for the same offense more than once. 300 provides person once convicted or acquitted not to be tried for the same offense, convicted or acquitted, or on the same facts for any other offense. Article 22 protects the persons who is prosecuted and punished, but it does not include acquittal. So that was said in Kolla Veera Raghavarao versus Gorantla Venkateswara, where Supreme Court observed that Section 301 of the CRPC is wider than Article 22 of the Constitution. Where Article 22 of the Constitution only states that persons who are prosecuted and punished, and it doesn't include the acquittal. But whereas Section 300, whether the person is convicted or acquitted, he cannot be tried again for the same offense, but on the same facts but on the same facts for different offences. Here in this case, the facts are the same, uh, the offences are different. So section 301 CRPC applies. S.A. Venkatramana versus Union of India. Here, the appellate was dismissed from the service as a result of an inquiry proceedings conducted by the Inquiry Commissioner under the Public Servants Inquiries Act 1850. Thereafter, he was prosecuted before the court for having committed offences under Indian Penal Code and also under the Prevention of Corruption Act. He said that he was already prosecuted and again prosecuting before the court is violative of Article 20, Clause 2 of the Constitution. The Supreme Court held that the proceedings taken before the inquiry commissioner is not a prosecution. The proceedings taken before the inquiry commissioner, it does not amount to a prosecution for an offense. It was only a fact-finding committee to give advice the government to take a disciplinary action against the appellant. So it cannot be said to be a prosecution, so it is not violative of Article 22 of the Constitution. And in Leroy Frey versus Superintendent District Jail, the accused was prosecuted and punished under the Sea Customs Act 1878. Later again, he was prosecuted under Section 120B of the Indian Penal Code for conspiracy to commit the act for which he has already convicted under the Sea Customs Act 1878. Again, the accused filed petition saying that it is a violation of Article 20, Clause 2. But both the offences are distinct and separate. If we read Section 120A, definition of the conspiracy, the bare agreement to commit a conspiracy itself is an offense. The bare agreement itself is an offense. And committing an offense is another offense. Suppose A and A, B, C agreed to kill X. The bare agreement itself is an offense, that is conspiracy. And suppose if they killed, again they are held guilty for offense. Murder. So both are conspiracy and murder are distinct offenses. So it is not violative of Article 22 of the Constitution. And right against self-incrimination. Clause 3 of Article 20 provides no person accused of any offense shall be compelled to be a witness against himself. No person accused of any offense shall be compelled to be a witness against himself. This clause is based on the maxim nemo tenetur prodire accusera ipsum, which means that no man is bound to accuse himself. No man is bound to accuse himself. When the accused makes a confession under the inducement, threat, or promise, it is violative of Article 20, Clause 3 of the Constitution. Suppose if the accused made a confession voluntarily without any inducement, promise, or threat, Section 20, Clause 3 does not apply. Because he himself voluntarily gave the confession, there is no inducement, promise, threat, etc. So it is not violative of Article 23 of the Constitution. In Dinesh Dalmia versus State of Maharashtra, the scientific test resorted by investigating does not amount to a testimonial compulsion. State of Bombay versus Kathikalu versus State of Supreme Court held that to be a witness is not equivalent to furnishing the evidence. To be a witness, the accused to be a witness himself is different from the accused producing an evidence before the court. To be a witness is different from furnishing evidence. Both are not equal. When it is a witness saying, confessing something, having a so self-incrimination must mean conveying information based upon the personal knowledge of the person giving the information. So if the accused, whether he has committed an offense, basing on what is the knowledge he had, whether he committed an offense or not, stating that statement is violative of Article 23 of the Constitution. But it cannot include merely the mechanical process of producing documents in the court. Producing document in the court is different, but not the giving information. The apex court in Selvi was the state of Karnataka He drew some conclusions. The taking and detention of DNA samples, which are in the nature of physical evidence, does not face constitutional hurdles in the Indian context. Not only the taking and detention of the DNA sample, taking blood samples, fingerprints, signature, or semen, or any blood, shedded clothes, or anything taken, hair, taking there will physical evidences. It does not come under the testimonial compulsion. So it is not violative Article 22 of the Constitution. Subjecting persons to narcoanalysis, polygraphy, brain fingerprinting tests involuntarily. Involuntarily. Suppose it is a voluntarily, it's a different thing. Involuntarily amounts to forceful interference with the person's mental process. Hence, it is a violative right to privacy under Article 23. A person administered the narcoanalysis technique is encouraged to speak in a drug induced state. And there is no reason why such an act should be treated differently from verbal answers during any ordinary interrogation. Expeditious trial. Everyone, we all know that justice delayed is a justice denied. So, fair trial has to be conducted without any undue delay. Fair trial it implies a speedy trial. Speedy trial is necessary to gain the confidence of the public. Delayed trial defeats the object of the resocialization of the offenders. Generally, the punishment we are giving not inflicting the pain. The object of the punishment is to make the offender, to resocialization of the offender, turning it a law-abiding citizen. So that object is also to be defeated if there is a delay. Delayed justice leads to unnecessary harassment. It also leads harassment not only to the accused person, even to the victims also, where the Nirbhaya case, they passed the judgment hanging, but the implementation of death sentence took so many days. So it caused harassment to the victim mother. She suffered a lot. So not only to the accused, but it also harassed the delay causes harassment to the victims also. Not and also public also. The right to speedy trial begins with the actual restraint imposed by arrest and consequent incarceration and continuous at all stages, namely the stage of investigation, inquiry, trial, appeal, and division. So how you can that get a speedy trial? We get the actual criminal trial. How you get actual fair criminal trial when the everything all the procedure comes speedy from that is the authorities in all at all stages of the proceedings, that is from the pre-trial stage to the judgment and issue of judgments must be done without any delay. That is within the reasonable time, all the proceedings has to be completed. That means the speedy trial is not restricted only into the court proceedings. Actually it starts by arrest and a consequent incarceration, and it continues at all stages. That is inquiry, trial, investigation, appeal. At all the stages it starts. If you look into the section 437 subsection 6 says if the accused is in detention and the trial is not completed within 60 days from the first date of fixed for hearing, the court will fix the date for hearing of the case. The first day of hearing the case, from that if the trial is not completed within 60 days and the accused must be in the detention. If the accused is left on the bail, again this provision is not applicable. If the accused is in detention and the trial is not completed from the date of first date fixed for hearing, the accused is entitled to be released on bail. But this only mitigates the hardship of the accused person because he was hardship, minimize the hardship. That is, he was in the jail. Now he will go and stay at home. So only mitigates the hardship of the accused person, but it does not give him any speedy trial. Secondly, this rule is applicable only in the cases of proceedings before the magistrate and not any other court. This rule is restricted only to the magistrate court. But section 309 subsection 1 gives directions to the courts with a view to have a speedy trials and quick disposal. So 309 section subsection 1 says every inquiry or trial proceeding shall be held as expeditiously as possible, particularly when the examination of the witnesses begins. The same has to be continued from day to day until all the witnesses in attendance have been examined. Day to day it has to be continued, no adjournment, but only in the court things fit after recording reasons can after may adjourn the same beyond the prescribed date. So from starting the arrest till the judgment issued, even the implementation of sentence also actually, everything should be done as expeditiously as possible, speedily. This is one of the fair trial principle. But in practice, but in reality, how it is to be achieved? Because millions of the cases are pending before the subordinate courts for disposal. So it's very difficult to achieve this object. Husinara Khatun was the state of Bihar. The court declared the speedy trial is an essential ingredient of reasonable, just, fair, guaranteed by Article 21. Article 21. This right to speedy trial is comes under Article 21, and it is a constitutional obligation of the state to set up such a procedure as would ensure speedy trial to the accused. The state cannot avoid this constitutional obligation just pleading financial inadequacy or administrative inadequacy. These are no excuses to the state obligation. The state has to set up some procedure to ensure a speedy trial to the accused person. Motilal Saraf versus State of Jammu and Kashmir. The Supreme Court explained the meaning and relevancy of the speedy trial and said that the concept of the speedy trial is an integral part of Article 21 of the Constitution. The right to speedy trial begins with the actual restraint, that is, the moment he was arrested, incarceration, and continues at all stages. Speedy trial till the final of appeal and the issue of judgment. And now I say that implementation of sentence also. Immediately sentence is also to be implemented, particularly death sentence. This trial judge drags for unnecessary long time is not a fair trial. The Supreme Court in A.R. Antule versus R.S. Naik issued a guidelines for the time period during within which different classes of cases are to be conducted. Different first they have classified the cases, and basing upon the different classes of the cases, what is the time required? That calculation has been made in A.R. Andale versus R.S. Naik. Further, it was held that the Supreme Court expressed its opinion that it is neither advisable nor feasible to draw or prescribe an outer time limit for a conclusion of criminal proceedings. The Supreme Court itself says it is not possible to fix a time bound for the disposing of the criminal cases. So, while determining the alleged delay, the court has to decide each case on its own, basing upon the seriousness of the offense, the number of the witnesses, the number of the accused, and also the workload of the court, a particular court concerned, have to be prevailing local condition. This is nothing but a systematic delay. So the aforesaid decision came up for consideration in the case of P. Ramachandra Rao, and it was upheld and reformed. One side, the Supreme Court says that Article 21 is an integral part of the Constitution. The state government has a state obligation and cannot say that because of financial or administrative strategies, it is not possible to implement it. No excuses to the state. But on the other hand, the Supreme Court says that it is not possible to fix a time bound for the time for the disposing of the criminal cases. So, one side it is integral part of it is integral part of Article 21 of the Constitution. It is a constitutional obligation on the state, but the court says it is not possible for them to dispose it very quickly. In Ranjan Dwivedi was the CBI Director General. The accused was tried for assassination of Sri L.N. Mishra, the then Union Railway Minister. The trial was pending for past 37 years. In view of the delay, the petitioner presented a petition paying for quashing the charges on trial, but it was held that the trial cannot be terminated merely on delay without considering other reasons therefore. So thus, these are the some of the important principal features of the fair trial. Starts these rights of the accused from, though it starts from arrest to the end of appeals and the issue of judgment and implementation of the sentence. But here this topic is confined only from starting of the trial to the judgment. So part one and part two together you have to be read. This is a complete answer. All the best.